I want to welcome you to the Young Lawyer section presentation on using technology effectively in a courtroom. We are very privileged today to present this seminar. My name is Christine Britton, and my co-chair Amanda Downs-Frizzell and I are presenting this seminar on behalf of young lawyers with the support of Eric Barron, who is our chair this year and has made technology his theme. We are very privileged to have on our panel the Honorable Mickey Norman from the Circuit Court of Baltimore County as our moderator. He's going to be presenting us the view from the bench with regard to the use of technology and issues and objections that come up in the courtroom. We have John Cord, who has been in 8 years of private practice in civil litigation and just went out on his own and is a user of technology on a regular basis. He helps other lawyers create their websites and does ghost blogging, and is the Charm City Lawyer, as his website has it. And you can find out all kinds of information that John can present for you. And he's practiced predominantly in civil litigation. We have Jim Gentry, who has done both civil and criminal litigation. He's a trial attorney at Salisbury, Clements, Beckman, Martyr, and Atkins, and is their tech guru, as I call him. For using technology in litigation. He's trained all across the country in seminars on how to effectively use technology through your litigation. So very privileged to have these speakers. We're also very lucky today to have Merrill Ladd, who is recording this for us so you can watch this over and over again on their website.
Good morning. You know, when I developed the slide that you're looking at now, I've changed it about 5 times.
And my name should be at the top.
Just because he's a judge. Well, yeah, and he said that to me before. He said, my name should be at the top. I said, well, but I created this, so. He asked me last night, we were talking, he goes, now he's doing technology for the Bar Association. And he asked me, he says, what's an app?
Well, you laugh. Can you put that app on this phone?
You're eating into my time now. But I was thinking about what I should call this. And the first heading was winning your case with technology. And I thought, well, no, I don't like that because technology isn't going to win your case. I said, well, improving your case with technology. I said, well, that's getting there, but still, it's not going to improve a bad case. It's not going to take a bad case and make it into a winning case. Because technology, and what I want everyone to walk away with today is technology, and that's what we're here to talk about. And we're going to do a little low-tech and a little high-tech. Technology is not a magic bullet. And don't think that what I'm telling you now and some of the things that you're going to see is going to win your case. It's not. It will improve your story because as trial lawyers, for those of us that are trial lawyers, that's what we do. We tell stories. And there's a lot of ways that we can tell a story. We can stand behind a podium, as was, well, it's still done today. We can stand behind a podium with a yellow pad, and we can tell the story to the jury by simple words. But I think any of us that have told stories to children with storybooks, what children want to see is they want to see the pictures. Well, you know, your audience, the jurors, are no different than the children that want to see the story. And we really have now changed the world that we all live in. With the advent of computers and with the advent of all the technology, iPads and even with the advent of television, we've kind of changed the way we learn. And I want to start talking just a couple of comments. I don't think I'm telling anybody anything they already don't know, and that is, and you may not know that 75% of what we learn is received visually, because we all understand that we learn by both seeing and by hearing. But today what we're going to talk about is the visual learning process. And you'll notice too, in creating this slide, because this sort of is a twofold message, in creating this slide, I don't want to put up for my audience, and that's you, too much information at the same time. Because if I have this up here and I have this up here at the same time, when I'm talking about verbal learning and I'm talking about how effective verbal learning can be, if I have that up there, when you're bored with what I'm talking about up top, you're going to start down here reading this information. So there are techniques that can be used where I show the first piece of information to the audience, and I want to talking about visual learning, and I can have another piece of information come in. And what I want to do is, after I talk about that piece of information, I want to kind of like make it disappear so people aren't focused on that, because I want them to focus on the bottom part of the information. And that is this sort of learning graph, and that 60% of information delivered verbally and visually is remembered after 3 days. These are just some statistics in doing some of the research about visual learning. And again, another statistic, and again, twofold message. One, the message itself, but how the message is delivered to you. Rather than just talk about or tell you that the brain retains new information for a few seconds, I thought I'd give you a visual of how this information, after a few seconds, can leak out. So we understand. So I wanted to create a visual of that. If I'm going to have you remember something, or if I want to persuade you about something, I'm going to also show it to you. We all know that there's two sides to the brain. There's both the left side of the brain and the right side of the brain. And again, this is in some of the research that I did in putting together some slides, that we want to send information to both sides of the brain. The audience, that's you, if you're the audience, I want to tap into both the right side and the left side. And we know that the left side of the brain is sort of a fact-gathering part of the brain. It's sort of the verbal. It's the logical part of the brain. Whereas the right side of the brain is more visual. And it works this way. You got the right and the left side. The right side, nonverbal, creative, visual with color, sensory, emotional, subjective, and then the list of things that work on the left side. So understanding that there's both a left and a right side of the brain, if you buy into this concept. The message is that I want to be able to create my story using as many visuals as I can. Part of the problem with, and this is a keynote presentation on a Mac as opposed to a PowerPoint presentation, part of the problem that, that some lawyers have in creating these presentations is they think that the slides should contain all of the information, and they jam it full of information. I'd rather, if I have a concept, if I want to talk about the brain, and I want to say a lot of things about the brain, I'm just going to show a picture of the brain on a slide and maybe a few points that I want to talk about, rather than have a laundry list of things that I want to discuss. Because what you want to do as a trial lawyer is actually plug in the jury with persuasion and communication. Remember back in the day, and I say back in the day, these are the old flip charts, and I'm not saying that low technology doesn't have a place in trials, but it's a combination of low technology and higher technology and more of the visuals. Because if you use just this, or you stand behind a podium and talk, what you're going to end up is a jury that looks like this. And everybody who's been a trial lawyer has experienced this. I have. There's nothing worse than standing in front of a group of people and you're trying to do an opening statement or a closing argument, and you know you lost them. You don't know how to get them back. You don't know why they're lost, but you know that you lost them. And they look like this. They don't buy into your case. They don't like your theory. They don't like you. And this is what happens. It's happened to every trial lawyer that's ever given an opening or a closing.
Reported early this morning that I could not find an objective Democrat who thought the race was not over, and here's why. Senator Obama, he has won 1,588 elected delegates, 260 superdelegates, a total of 1,848. Senator Clinton, as you can see, 1,422, 273 supers, a total of 1,695.5. You need 2,025. That means Obama's 177 short. Clinton is 327.5. Where do they come from, Brian?
Does anybody remember this? This actually, I remember watching it, and with the whiteboard, and Tim Russett got a lot of praise for it. I mean, people were applauding him, and they loved the idea that he went back to the old whiteboard and hand wrote the things on there. And I thought, they had available, and we've all seen it when they're covering elections, they have available all kinds of technology. You know, where they put the big screen up there and the person comes up and he can swipe his hand and he can move the map around, and he can, which is kind of cool. But then Tim decided, I guess, that he was going to go to the old school way. And so I thought, you know, this is something that we can use and as a part of our trial in conjunction with higher technology. John is going to talk about bullet points. And I want to mention bullet points because this can be a nightmare. Has anybody put together a PowerPoint presentation? Who out there has done it? Now, I would bet you, and please don't take this wrong, I would bet you that the people that put up their hands used bullet points, didn't you? Bullet point after bullet point after bullet point after bullet point. Sometimes it all comes up at one time. A slide filled with bullet points. Let me just tell you that ain't the way to do it. There are better ways to do it. There are better ways. I'm not saying you can never use bullet points, but there are better ways to do it. I never want to put a bullet point up there that says everything that I'm going to say, because I don't want to read it. I mean, it can be a crutch. PowerPoint or Keynote or electronic presentations can become a crutch. And lawyers that get up there with the presentation, they feel confident because it's up on the screen. And what do? They end up taking a back seat. And they end up basically letting the PowerPoint presentation do the work for them. As trial lawyers, it's your audience, they're your jurors, and you are the star. You should never take a back seat. PowerPoint or Keynote, these presentations are aids to what you say. I mean, just because we have PowerPoint doesn't mean that we can't be eloquent. And when speaking to a jury, we want to be able to talk to them, to have a conversation with them. And it doesn't work. You can't have a conversation when you just put bullet points up there. It's easy to do, but there are other ways to do it. If you have a concept, if you're talking about a particular topic, and you want to convince the jury about whatever it is that you're saying to persuade them, think of a visual. Use your imagination to come up with a visual that you can use, and maybe a couple of key words that will lend itself to a discussion. The great thing about PowerPoint is that after your slides are all put together, you'll never forget it. You're going to sit down and say, gee, I forgot something, because it's up there. You may forget some of the things that you want to say about the slide, but you'll never forget the topic. So PowerPoint or Keynote is a great tool to use as an aid to you, the star of the show. Here's a little clip that I found that kind of hits home the point.
I hate this. Avoid excessive bullet pointing, only key points. Too many bullet points, and your key messages will not stand out. In fact, the term bullet point comes from people firing guns at annoying presenters.
Now, I bet everybody here at some point, the younger ones maybe in college, or the older ones at some seminar, have sat there in the audience with a speaker that uses PowerPoint and uses bullet points, correct? And now, with that said, now the bullet points, some of the people that create the presentations that are just learning find some really cool things, right? Sound effects, whooshing sounds. The thing can come in and spin, drop down. And so they think it's cool. So they have all these animations in their PowerPoint with sound. So it's whoosh, and then it comes in and it zooms and it sits there. Now, the first one might be cool, but then the second one, the third one. By the time you get to the end of the presentation with this speaker, who really thinks he's jazzing it up, has annoyed the audience, and they become very bored with this kind of presentation. And the jurors are no different. So when creating these presentations, and again, John will talk about this, when creating these presentations, leave out the jazz. John is going to talk about some simple ways to put together presentations with the right color and the right text and the right font. I wanted to give you, these are all slides that I created and that were used in actual trials in our firm. A couple of which I tried, but one of the things that I do for our law firm is I'm sort of a consultant with the lawyers. We try mostly medical malpractice, so I put together all the presentations for them. And then I work with them in rehearsing the presentation so they can give it in opening. So we have timelines. I'm a big fan of timelines, a huge fan of timelines, because timelines keep everybody organized. And there's a lot of different ways that you can make some timelines. John will talk about one of the ways, sort of the lower tech way. But this timeline right here is something called BDocs. It's a timeline that is an app. App stands for application, where you can easily create a timeline that's kind of cool, but it's effective because the timeline actually moves. So when I click a slide, the time actually moves like a real timeline. I'm a big fan of clocks. I mean, if I want to talk about an important time, 10 o'clock in the morning is the important time in the case, I'm going to tell them it's 10 o'clock, but I'm going to show them a clock. So I created clocks, and this is sort of a summary slide that I think was used in a medical malpractice case that we had. Sort of the last slide to do this.
I hate to interrupt, I just have to ask, in terms of the evidence issues and getting stuff up on the board, how do you handle getting any of these depictions up there?
Wow, we have the question of the day, and that's exactly what we're going to talk about. Yeah, that's a good question. You and I, Kimasabi. We're going to talk, that's exactly what we're going to talk about, and that is these slides were all slides that were used in the opening statement in the cases. And we're going to talk about, believe me, when we got involved in putting together this presentation, all three of us, we found out that the law dealing with computer-generated evidence is a whole lot more complicated than we ever thought. And we started digging deeper and deeper and deeper, and we found out it's not as simple as I once thought in order to use some of these things. So we're going to talk about how we can use these in opening, in closing, and during the trial itself. But these are different slides. These were actual individual slides that were used. And we have home movies, web pages, call-outs. We're going to show you some examples of documents. Probably, besides timelines, in trials, both in opening and closing and during the heart of the trial, we oftentimes rely on documents. We introduce documents in medical malpractice cases or in accident cases if we're trying a tort case. We have lots of documents. You know, we introduce binders and binders, like in medical malpractice cases, we introduce like 3 big binders of medical records. And we do it, but I don't know why. Nobody ever looks at them. Nobody ever reads them. Nobody could ever understand them. So what I want to do is create some of the documents that are important. So with timelines, the second probably most important use of PowerPoint or Keynote is the use of documents, because this allows you to very easily display documents and important parts of the documents, call-outs for the jury so everybody can read it. And they can all be, and we're going to talk about, they can all be scanned and put into these presentations. Here's a slide where there was a document and a call-out that's highlighted. When the and I'll show you in a minute, when the document comes up, the call-out comes out, and it's an extremely effective way. Boy, I tell you, graphics. Now, here's one graphic. You can't see it real well, but the point is that it's a graphic. I could have created a whole bunch of bullet points, but rather than that, and this is a graphic that was found actually in PowerPoint, there's so much in these two programs, both PowerPoint and Keynote, that if you use your imagination, you can come up with some ways to depict the information or to summarize the information other than in bullet points. We're now going to talk about, or John will talk about, the nuts and bolts of technology. Some of the things that we can all do fairly easy, fairly easy? Easily. Fairly easily.
That's a new app.
Yeah. The English language. if you hear a little banter back and forth between myself and Judge Norman, that's because we've been friends since we were 14. And we went
for 14 years now.
Went to high school. Went to high school together, college together, law school together. Worked in the state's attorney's office for 20 years together, side by side, and then he became important.
Why is it my name at the top?
But yeah, I'll change that. So John is going to talk about some of the nuts and bolts.
So the most important thing that some people came to this presentation for is to figure out, how do I do this stuff? And you saw some of Jim's examples. And for people who are in the position of never having taken technology to trial, you might want to know, what do I need to get started? So, you know, for especially the solo practitioners or the small law firms, these are some things that you can do completely on your own. If you're a bigger firm, you can hire people. You can get Jim over to come help you put together really terrific presentations. But if you're, you know, an auto practitioner, for example, and you've got a half-day jury trial in the city court, you can do this completely on your own. Lug the technology up yourself, put together the PowerPoint or Keynote if you're a Mac guy, and do this all on your own. It's all very doable for really people of any technological sophistication. So again, my wife's a teacher, and so I've been impressed over the past 10 years about what even teachers are doing in schools now. It's not lecture like it was when I was a kid. It is very much more whiteboards, and not the dry erase boards, but technological whiteboards and presentations like this. So things to combat lecture fatigue, because people don't learn very well with lectures, as we all remember from college probably. You can get a projector, so we've got one right here. You can spend anywhere from $500 to $1,000 more if you wanted to, but you know, a $500 to $1,000 projector will do you just fine. A projector screen, there are a bunch of different types of projector screens that you can get. This one's obviously hanging from the ceiling, so your courthouse might have that available, but you're probably going to want something a little bit more portable. I usually recommend the tripod screens just because, in my mind, they're easier to set up in most courthouses. Sometimes you have to stick them back in the pews where the audience sits, but they also have ones that roll out of a tube, so it's basically a long flat tube on the ground that you pull up. Those are a little bit harder to place, in my opinion, but you know, something like that, very, very cheap expense. And then you need a laptop, and that's it. This is your entire technological equipment base. This is all you need to put it together. So again, and I don't know if everybody can see, but Jim's got his laptop down there. It's connected to the projector. It goes right onto the screen. That's it. You know, if you want to get extra fancy, you can add other tools, a little wireless presentation device, or you can just go up and, you know, if you have your laptop closed, you can just hit the button and move things forward there. So this is basically all you need. For software, in order to put the program together, I always recommend that everybody get the latest version of Adobe Acrobat. This isn't Adobe that comes up pre-installed on your computer. That's Adobe Reader. Adobe Reader sucks. It doesn't do anything. It allows you to see other people's great documents, but it doesn't allow you to do anything with it. So Adobe, right now, they're up to Adobe Acrobat 10, Acrobat Professional 10, which is just a fantastic device. It will serve you well in your law firm. Presentations aside, you can OCR documents, which means you can basically take PDFs that other people send you, search for words in that, and find them. I had a medical malpractice case once where we had probably 15,000 pages of documents. I set the computer up, OCR'd it. A day later, admittedly it took a while, I was able to take those documents into depositions, and when a doctor said something, Control F just to find a word, and then I'm immediately there every time that word is repeated in that document. It's really a tremendous tool. As far as your presentations here, Adobe has a whole lot of capabilities, the most important of which is that it gives you the ability to copy portions of that document, and then you can paste them into your PowerPoint or Keynote presentation. There are other things you can do to do that copying thing, but Adobe Acrobat, it really gives you a lot more options. Camtasia Studio, if you're going to be using video at trial for whatever reason, this is an important thing to have. I can't remember the exact price. I want to say it's like $250 or something like that. But what we've done in some of our past trials where we had, for example, I had an auto accident case. We wanted to show what a particular injection was like. And so we got a YouTube video, used this to copy the video from the YouTube site, and then gave that to our expert, who basically authenticated it and narrated it for the jury. This is what this particular injection looks like. This is how this surgery should be done. And it's really just a great way to get anything that you want off of the internet saved onto your hard drive so that you can then present it to the jury. Because obviously you don't want to rely on an internet connection to get your main evidence into in front of the jury. LexisNexis is a company. Everybody knows Lexis. I mean, they do all the software and everything. They create a product called Time Map, which is what I use for timelines. And I'll show you some of those later. There are a bunch of other products that you can do. That's just the one that I use that I think is really, really simple. And then Microsoft Paint. You can do a whole lot of things with Microsoft Paint. If you want, and if you're really a techie type person, you can get into the Adobe Photoshops and all of that. But if you're just putting together something on your own, there's a lot you can do with Paint. You can copy things from the internet and then adjust pixels. You can change things around. You can put two pictures together, and then from there you save that as a document and put it into your PowerPoint slides. Keynote or PowerPoint, and that's really the majority of the software that you need to put together a solid, hard-working PowerPoint or Keynote presentation. Supplies. I always take into every trial just a box of things that I need in addition to that. So in order to do this presentation, you're going to need some sort of, and it didn't show up with the white, but some sort of table, like a card table to put the projector and your laptop on. Extension cords, power strips. I always back up every presentation on a flash drive or 3 flash drives, just because I'm crazy paranoid about it. Duct tape so that your jurors don't trip over your cables when they're crossing into the jury box. A set of speakers, and Jim's got some of these speakers right here, which are fairly sizable. But for most juries, if you've got a normal-sized jury room, you can get these little speakers that are really about that big, and they really have good sound nowadays. It's very appropriate. It doesn't require you to lift a whole lot of stuff, because the goal when you're going into trial is to have as little as possible, because especially on a hot Baltimore day, you don't want to be sweating before you get into the courtroom. And then a mouse. And so these are some of the basic things that basic supplies that you need. So Jim actually did a good job talking about the bullet points, which we don't like. The goal is to do pictures. The goal is to take your evidence and present that to the jury. You are going to have to use text, though, in your presentation to some extent, whether they're for titles or the occasional deposition, that type of thing. In the handouts that I gave you, I talk a lot about fonts and colors. I'm not going to spend much time here. You can read it there for whatever you want. Just know that if you're into typography, you can go no holds barred at this type of thing. But basically, there are 2 types of fonts, serif and sans serif. There's a whole lot of debate over what's the most readable and when it's appropriate and that type of thing. For my purposes, I usually try to use sans serif, which means they don't have the feet and the little added accents for the headings. And then for text, where it's more text at once, I think people are more used to reading serif, in the newspaper and books and that type of thing. And so I think it's more readable that way in that sense. Keep in mind your fonts, they need to be big enough for people to see. So you're putting it together on your computer, do a dry run, figure out about, in the courtroom, how far away is the projector going to be from the screen. You need to make sure that the last juror at the end of the row is able to see this stuff. And then colors, I have a lot of things about color in the handouts I'm not really going to get into here. So what can you do with your presentation? Jim talked about a couple of things, but the important thing is application of your evidence. So you go through discovery, you get a bunch of documents, you get photos. These are some of the things that you can use. This would be a bad thing to do in trial, but this is just a list of all the sources of material for your presentation. Diagrams and treatises, we use this sort of thing with our experts. You get your expert to talk about a medical journal or something that's appropriate. You can copy that in using any scanner. Or go to the website of these companies. Sometimes they have these documents electronically available. And then you have this. So this is a crowd management case that we did once upon a time. And these are some of the standard of care that the company putting this event needed to follow. And then with just some simple animation, you highlight one and you say, did the defendant do it? No. And so then you talk about it. So just very simple things you can do, pulling stuff from treatises that are useful. Again, pictures or drawings from treatises, And this is all, let me go back just to explain it. This is, when do crowds become too packed in to be safe? And so this is just something from one of those types of treatises from the Crowd Control magazine or something like that. And then you get to a picture of the actual event, and you can see it looks very much like that last one. All you can see is heads here. It's too packed. It's an unsafe event. Exhibits. So when you have requests for production of documents, or you have deposition exhibits, all those things can be copied and put right up into your PowerPoint. This was a deposition exhibit that one of the defense witnesses drew for us, and it was an easy thing to put in front of the jury to help explain the case. Plaintiff's injuries, you can talk about how the plaintiff is injured, and you should talk about how the plaintiff is injured, but sometimes your visual presentation should be an exercise in contrasts. The juxtaposition between A and B is really something that can be used to make a strong point. So you want to use these contrasts, whether it's color or documents. So this is the plaintiff's handwriting before this incident. This is his handwriting afterwards. He suffered major brain damage because of this crowd crush incident. He lost oxygen to his brain, and he was obviously not able to function the same way that he was before. And this is just simply, the age-old lesson of a picture tells 1,000 words. Okay. You're going to keep in mind when you're looking through the evidence code, what you need in order to prepare your case. What are the evidentiary rules? In this one case, we needed the weather certification for what the official Baltimore City weather was on a particular day. It had an issue to do with when ice was freezing, whether the ice could have frozen, how long the ice had been there. And so we needed to show the temperature in Baltimore City for a few days before this incident. So you scan that up and you show it to the jury, because you can have the little thing with the seal and you can hold it out, but you can also put it up. And then in terms of the data from that, it's a chart. It's hard for people to see. It's hard for a juror to read. What you can do with PowerPoint is cut out specific portions of that you might need. So this is the first column, that's the second column. They're very far away, it's hard to see what it is. Get all the extraneous material out, move it together, and then highlight the important parts. And this way the jury can see, because this is all straight from the document. I didn't type any of this out. They can see that I'm not messing around with the document. All jurors think that we're all liars. Lawyers, liars. And so this gives you a little bit more credibility. You are showing them through the documents that this is something actual. I didn't make this up. This is from the evidence itself. I'm not telling you one thing, and you can believe me because I'm showing you the document itself. Okay. Maps, Google Earth and Google Maps are just the best thing ever. You can copy that and put that in your presentation. To the extent that you have maybe auto accents or whatever, you can put specific pictures in. So in this case, I used arrows to sort of symbolize the cars. And going back to the color thing, which again I talked about in the materials, red is bad, blue is good. Oh look, the plaintiff is good. I'm a plaintiff's attorney, so not to disparage anybody who does anything else. Long, straight, narrow pathway. So think about what your evidence shows. Think about the pictures that you choose for your case. This was a rear-ender case, and we wanted to show that the defendant clearly knew that the traffic would have been backed up because he was up higher, he was on the crest of a hill, and it's a long, straight pathway. So it shows negligence. Again, more maps. You can animate it to some extent if you want. This is where the first car goes, stops there, second car comes in, and then impact. It's very basic, but in opening, the hardest thing is to give a jury a sense of what happens. How often have we been in a district court trial and you're telling up there an opening, or the witness is trying to tell the judge what happened, and it's just a mess of streets and directions, and you don't get a clear sense of what it is. Sometimes you want something just very simple that shows, here's the intersection, this is what happened. Guaranteed, it looks a little bit silly, but the judge or the jury is going to have an idea of what the case is about, and then you can move from there. Photographs, very easy. Medical illustrations. The internet is a very great resource for all this stuff. You can go to any number of reputable sites. MayoClinic.com is one of my favorites. They've got tons of stuff there, including videos that you can look at. And then basically just take these documents, make sure your expert looks at them and tells you that, yes, that's all accurate and correct. and then you can show, we had a fracture case, that's where the fracture was. Any exhibit that you make at trial, so if you have a company like High Impact or any of those other medical illustration companies come in, they'll give you the big board, but you can also have them send you an electronic version of that. Or if you have old boards that you've used, I know some lawyers tend to use the same things for years and years on end, and this was an exhibit that we had at a prior firm that was just a hard copy exhibit. I just took a digital photograph of it, uploaded it to my computer, and it goes into PowerPoint. So now I don't have to lug that big, annoying piece of foam core board around everywhere. Again, medical journals gives you all sorts of stuff. So for birth injury cases, or for, this was an RSD case, it just gives you the ability to show the jury whatever it is that you need. And if you need to pull out one specific section, you can do that. It's more flexible than a foam core board. Depositions, and Jim will talk a little bit about this, but depositions through any company, whether you use LAD, who is kind of the sponsor here today, they can sync the transcript with the video. Okay, and in this case, it was pretty good. Dr. El Samanuti, he speaks with a very heavy accent, and so we were able to sync that together so that in case the jury couldn't understand directly by listening to him, we have the text there scrolling at the same time, which makes it more likely that we get our point across. And then again, if you want to pull out a specific part of the trial transcript or the deposition, stick up a picture of the doctor's, the talking head, as it were, just so that the jury can remember who it was. So this was a slide that we used in closing. And you just want to make sure they remember which doctor was yours, which was the good doctor, as opposed to the other side's doctor. Okay. Radiology, most hospitals will give you these films on CD or electronically somehow. If you have hard ones, again, same thing works. Put it up on your light box, take your digital camera, take a picture, and upload it. And then from here, there's a lot of things you can do with radiology. You can annotate it with text. You can highlight it with marks. This is an MRI. We're talking about a specific section. So you magnify that up and then show the disc protrusion. So it gives the jury a very clear idea that this section is different from those sections. This was one where we were showing a particular injection. Imagine that's a needle going into your back. It gives you a little bit of the ooh factor, which is a lot better than just showing somebody, yeah, the needle would go in here. Okay, medical records, you just pullouts. And again, sort of like the weather thing that I talked about, pullouts are the most important part of almost any case, because you don't want the jury to see the whole document because it's too hard to go through the whole thing, and the whole thing isn't important. So to establish credibility, you show them, this is the document, you can't read it and that's fine, but now we're going to pull out the most important part of it. And that way they get an idea of what you want. Timelines, this is LexisNexis's time map, which I use. You can do a bunch of different types of timelines with it. This is one. And then sometimes what I'll do is I'll copy those areas, and then in moderate bullet points, put up the list of important things based on that, or important things that happened at this time. Photographs, anything that you've got can be used here. And then again, you can really highlight to the jury where everything is or what they need to be looking at. You direct their attention through these animations or through the annotations that you use, again, all through PowerPoint. Okay, spinal stimulator implant in one patient. I mean, it's a good picture. This is a device that this woman has implanted into her, and it creates this bulge, and who would want that in them? So it's anything that you can do to get a reaction or to really illustrate your point, because I didn't want my client to have to get up there and show them, but this was a big deal to her. This is this was a significant medical procedure and something she has to live with, and so we did the picture, and it really kind of sells it. Medical expenses, if you get to a situation where you need to, we transferred this from Keynote, but ordinarily those should be lined up. This way you can list stuff out. This way, because again, when you start talking dollars, to a jury or numbers, sometimes they're trying to write it down furiously so they can keep track of it. This way it makes it just a little bit easier for them. The verdict form, something I like to do at the end of every case, show them a copy of the special verdict form. This is what the judge is going to ask you to do. They haven't seen the verdict form, which makes it kind of hard. So I show them, this is what we've submitted, this is what the judge wants. Okay, and this it didn't transfer as well from Keynote as I wanted. But then you have to tell them what to do, because it's confusing. These things are horrible to read. You try to make them as simple as you can, but you really need to give the jury the opportunity. If you agree with us, this is what you do. Number 1, do you find blah, blah, blah? Yes. Number 2, yes. Number 3, yes. Number 4, no. Number 5 is irrelevant because you hit no on 4. And then 6, and then you go through. The medical expenses, you tell them, this is what our doctor said the medical expenses were. And then there are a couple of different styles. Some people will use this and list out all the damages. At this point, sometimes what I like to do is I like to go low tech. And so then I will pull out that flip chart and I will say, okay, so let's talk about the non-economic damages. And that, you get the flip chart up really close to the jury box, and you make that bond with them and go through how they can calculate non-economics, for example. So it's just about using the combination. These are some slides I did with the closing that's, we don't really need to get a whole lot into, but the important thing is that a closing argument is not something that you can always prepare for in advance. Your closing argument is going to change depending on what happens in the course of the main trial. And if your closing is right after lunch, or you don't even have that much time to do it, sometimes you have to put together stuff based on the most recent witnesses right on the spot. And there are a lot of things that you can do that. And again, the video depositions through LAD or whatever court reporting company you use, you can put up video clips and make those clips while you're sitting at the trial table. It takes about 15 seconds to make a video clip using the software that those companies provide you, which is great. And you can also go through, if you've got the depositions, you just cut out those portions that you need, or if you've got the trial transcript of anybody, which the court reporters in the courtroom can give you, or anything like that, then you just show the jury, these are the points that we didn't like. This is how the doctor was wrong about this sort of thing. And then backups. Always have some backup. So, for example, for my presentation, in case it went totally down the tubes and the electricity went out, I at least know what I'm talking about. So I've got all of my slides printed out with whatever notes that I would need in order to tell you. And jury trials are the same way. Make sure you've got your notes so you know what you're going to talk about. Make sure you've got maybe some exhibits or marked exhibits that you can pass out if you need to, in case this stuff fails, because it does happen. Nothing's perfect, but by and large, you're not going to have to use that stuff because you've got it all on your computer. So.
This is an app. It's called paper. Jim mentioned this when the three of us got together to discuss how we were going to present this. We had talked about my role being, since I'm a judge, to discuss the law. And before I get into that, I can tell you that when I was a prosecutor, Jim started using PowerPoint a number of years ago, and I started using it after him, and it's way fun. If you've never done it before, he uses Keynote now, but it's a lot of fun. It really does help in your trials. It can be addicting, I will say. I was up at 2 o'clock in the morning trying to find the noise of footsteps to insert in a PowerPoint presentation when I realized, okay, you really lost your freaking mind. But it can be a lot of fun. The rule that I'm going to talk about is 2.504-3, right? And that's the primary focus of the rule. And when Jim and I and John started talking and we started discussing the rule itself, and as Jim mentioned, he had a particular take on this rule. If you read it, it says, what computer-generated evidence is. And this rule was created in 1998. It's been modified slightly. But what it talks about is a computer-generated oral, visual, or other sensory depiction of an event or thing and a conclusion, oral, visual, or other sensory form formulated by a computer program or model. The discussion that was engendered was whether or not the and was conjunctive or inclusive. Could you replace the and with an or? Well, it turns out that if you look throughout the remainder of the rule and in other rules, it is not meant to be conjunctive. And this kind of flies in the face of other existing case law, and I'll explain what I mean by that in a second. So first of all, what you can see what computer generated evidence is in our discussion. And you know, we get a bunch of lawyers together and they think they know what they're talking about. We actually wound up having a discussion in terms of whether or not, compared to some of the case law, this rule needs to be changed, and I'll talk about that in a minute. Some of the things that computer-generated evidence is not is, for example, and it's right in the rule, and I'm not going to read the rule to you, you can do it yourself, but it's photographs, for example, taken by a camera that has a computer in it. It is summaries. It is word processing. You use computers all the time to do word processing. And that's not considered computer-generated evidence under this rule. There's also a criminal rule, 4322, that's slightly different, but it refers back to this rule. There are a couple of other requirements. There's a notice requirement. If you're going to use computer-generated evidence, you have to comply with the scheduling order, or if there is no scheduling order, and again, this is found right in the rule, 90 days before trial. And then once you provide that notice, you have 5 days to provide, and this must be done in writing, provide to all the parties what that computer-generated evidence is. And that can get a little tricky as well, because you're thinking to yourself, as Jim and I had this discussion, as well as John, well, why should I have to disclose my opening statement to you, which is something we're going to talk about. And if you, once you have received that information, now you know the other side is going to use computer-generated evidence. You have 60 days, according to the rule, to note an objection. You can use, you can object on any grounds the rule says that it's then available, but particularly it talks about, there's a rule 5901, and I'll talk about that in a moment. You have to specifically identify if your objection is under 5901. 0.9, you've got to let the court know that, or it's forever waived. As a result, if there is an objection, then there's a hearing. Depending on what kind of computer-generated evidence it is, the hearing may be rather simple, or it may be quite extensive. I would commend for your reading, besides the rule itself, there's a case called Lorraine versus Markle American Insurance Company. Actually, it's a boring case in that it's a federal case and it's boring in terms of its substance, but Judge Grimm wrote this. And if you know Judge Grimm, the man is brilliant. And the case itself is about a federal arbitration, and each side files a motion for summary judgment. Judge Grimm denies the motion for summary judgment primarily because they did not, neither side complied with the rule. And the rule was about certification or authentication of certain information. It was a contract case, and most of the contracts, or the elements of the contract, or the discussion of the contracts, were created as a result of emails. And the question became, well, how do you authenticate that? The point is, in this particular case, and it's a lengthy case, but it's worth reading. It's the best case I could find out there that describes computer-generated evidence in a broadband. It talks about emails. It talks about the kind of stuff we've been watching here. It talks about electronically stored evidence. It is a great thesaurus to understand computer-generated evidence. So going back to...
Do you have a site for that?
I do. Yes, sir. I'm sorry. It is 241 Federal Rules Decision 534, and it's a 2007 opinion by Judge Groom. It's a lengthy case. You know, the substance, as I said, because I don't do that federal stuff, but in terms of reading and learning about just how, I mean, he breaks it down, and he breaks it down in terms of hearsay, non-hearsay, excited utterance. He compares it to the existing evidentiary rules, which, of course, the federal rules are very much like our rules. All right, so when we talk about the "and" part here, as Jim and I, we had this discussion because, you know, he walks into court. He stands up to do his opening statement. He clicks his magic little mouse, or whatever it is thing he calls it, And somebody stands up and objects and says, Judge, I object. We didn't get this. And the rule says he's got to give it to me. Now, Jim's original opinion was that he didn't have to give it to you because Maryland law doesn't require that you provide your work product. And let me pose this question to you. If an exception to computer-generated evidence is word processing, and it is, it says so right in the rule, that's an exception. Well, John and Jim just, this is computer-generated evidence according to the rule, but all this is a word processor. I'm putting up on a screen, in a slide, what I could stand up and write. So the anomaly, if you will, is if I stand up in front of a jury with a whiteboard and a big magic marker, and I'm talking about, ladies and gentlemen, you are going to be introduced to this case, which is a traffic accident, and I'm talking about preponderance of the evidence for whatever reason, an opening statement. And I write the word preponderance up there. I can do that. And if the other side says, object, what's your objection? Well, he's writing, so what? He can do that. But the interesting thing is, under this rule, the way we read it, is if you put it in some sort of presentation like this, you got to give it in advance. That makes no sense to me. So in our discussion, and I think we'll talk, we have talked about this, and we will talk about it in terms of opening statement and closing argument. I think that at some point, this is Mickey Norman, okay, are no appellate judges here? Very good. We know they're going to the dogs. Come on, that was a good one. I think that the rule, here's the deal. If we are going to keep the idea and perpetuate the idea that what you do as trial lawyers is important, and you should be given a certain amount of latitude, both in opening statement and closing argument. And we know that opening statement and closing argument are not evidence in the case. We tell jurors that. So the question becomes, why should you have to give that up? And I think you're going to see some interesting debate about that in the future. There's a difference between, there's a primary difference between the what we call A1 and B1, and the rule talks about it. And Judge Murphy's book at section 302 says this. It says it doesn't make any difference if it's A1 or 1A or A or B. It doesn't make any difference. That is the 1 or 2, because it still engages the rule. Now the difference between those two is major. The difference primarily is the difference between illustration evidence, and we're going to show you some of that, and simulation evidence. And here's the major distinction between them. And again, I'll talk about simulation versus illustration. Illustration, to start with, is nothing more than demonstrative evidence. A few moments ago, John showed you an intersection in the Essex area of Baltimore County, Eastern Avenue, and I forget what it was. And he showed you arrows. Now imagine this. In a trial, either in opening statement or in closing argument, you could stand up there in front of a whiteboard and draw an intersection. And you could draw arrows depicting the travel of a particular vehicle in a particular vector. You could do that. And that's not discoverable. You're not required to let the other side know about that in advance. You do that in this form, given this rule, it looks like you have to. In terms of demonstrative evidence, a hearing that might be required. Let's talk about that just for a moment. So let's say Jim Gentry provides to the other side a written notice that in opening statement, I'm going to use a PowerPoint presentation that has 5 slides in it, Dr. So-and-so, and 10 documents, all of which are coming into evidence. The other side says, I object, I want a hearing. Well, the length of that hearing is going to be very brief, because we're going to come in, Mr. Gentry is going to say, number one, it's not evidence, it's opening statement. And like any other opening statement, I expect to show in opening, what I know will come into evidence. So that kind of hearing is going to be very brief. On the other hand, simulation is different, and Judge Grimm talks about this, because simulation is not merely demonstrative evidence. Simulation is basically taking data and sticking it in a computer program, and it comes out with an answer. It is actually expert testimony. So in a situation where someone objects because you now intend to introduce a simulation, a much more extensive hearing is required. I will point you to this particular case. This is the one case that everybody cites in terms of simulation. It's called Commercial Union versus Boston Edison, if you're interested. It's at 412 Massachusetts, 545. And that's a 1992 case. And it's a civil case, very complicated, and there was a particular program called Trace. And this program, basically you fed data into this program, and it gave you an opinion. Now what the court said in that case was, you could have a human being expert do that. That is to say, you could give a human being that same information, and he or she would apply whatever algorithm that they would normally use to come up with the same information. But it would still be expert opinion. So as a result, in that circumstance, now the computer and the program become the issue of challenge. It's almost like having a Fry-Reed hearing. So you got to determine, was the computer working correctly? You have to have somebody explain the program, and you, just like in an expert, is it generally accepted in that particular community? So the big difference between simulation evidence and illustration evidence is one is demonstrative. Again, there needs to be a foundation, but usually that foundation for demonstrative evidence will come in the form of witness testimony, eyewitness testimony. We're going to show you a little bit about that in a moment. But if you have a traffic accident, in the same way you could draw your intersection, you have your witness on the stand, he or she testifies about what their personal observations were. You would get all of that out. And then you would be allowed to, once you've laid that foundation, you should be allowed to say, is this a fair and accurate representation of the incident as described by you? It's not an opinion. It is nothing more than a visualization of what that person saw. You talk about animation for a moment. In 1937, Walt Disney, and I know there are some people in this room who have no idea who Walt Disney is, and that's just scary. But Walt Disney created the first full-length animated film. Anybody know what it was?
Fantasia?
No. Snow White and the Seven Dwarfs. Now, even as I say that, I know that's politically incorrect somehow. But it was Snow White and the Seven Dwarfs. Fantasia was 1940. Now, if you've ever seen how it's done, you know, all it is, and Jim has a clip on this, all it is a series of stagnant frames that are filmed. And it gives the sense of motion. It's not really moving, but it's demonstrative. Now, I point that out for this reason. When you stand up and you draw arrows, it is not as compelling as seeing something apparently move. So one of the concerns that is throughout, I did a bunch of research all across the country, and one of the major concerns is the fact that these kinds of presentations are so compelling that the jury must be reminded that it is an animation. It's not necessarily an actual depiction of what happened. There's a Pennsylvania case. I have the site, but I forget it offhand. But it was a murder case where I'll get the site if you want. But it was a murder case where the state notified the defense in advance in a motion in limine, a proactive motion in limine. Say, listen, we want to present this PowerPoint presentation to the jury. It was a murder case where the defense was, it was self-defense. A man murders his wife. He alleges it was self-defense. As a result of, the court conducted an extensive hearing on pre-trial. And basically, it was a combination of the police investigators testifying, the forensic experts testifying, the medical examiner testifying, and all that was put together. That was the foundation. It was no different in many ways in terms of what they did. They took stagnant photographs of the scene, all right, but then they created an animation, but they had all of that other information that would normally be used to testify. That is a fair and accurate representation of what the living room looked like when I got there. That is where the body was laying when we first arrived. And then there was an expert in that case that talked about how it was clear that the body was rotated or moved. So the court conducted a hearing, and it ultimately allowed the PowerPoint presentation to be presented to the jury, and that was affirmed on appeal. But one of the things that the court instructed the jury as a part of the instruction was, this is a demonstration. We're not saying that you have to buy into it. This is just a demonstration to help you understand the testimony that's been presented. So if you leave here with nothing else, read that opinion written by Judge Grimm, read this rule, and we'll talk about how we use it in court.
I could be wrong.
Yeah, you could.
I could be wrong. But I thought it was Steamboat Willie too. Okay.
Full feature. Full-length feature. Okay?
I could be wrong.
Look, I got on my.
I thought it was Steamboat Willie.
I got my app, and I checked it yesterday. It's not. It's Snow White and the Seven Little Guys.
Okay, let's now get a little more specific in using all of this in opening and closing.
Is that okay?
And as it relates to computer-generated evidence. I really did. I thought in reading of the statute, and I always argued, sometimes won, that computer-generated evidence and the notice rule is only triggered when you have evidence that you've created on a computer and you draw a conclusion using a computer program. I thought it had to be both. So if it wasn't a program that drew a conclusion, then it wasn't computer-generated evidence. And I was wrong. I think in reading the statute now and doing the research that we did, that it is either A1, that is if it's some kind of whatever it is that you generate on the computer, outside of the exceptions. It's either that, or if you have a program that generates an opinion, that's also computer-generated evidence. The scary part of it is, in what I do, oftentimes I'll come up with ideas for opening statement, and it could be a couple of weeks before the trial. We're putting now together our opening statement. I want to be visual. So I might use a medical illustration that I find on the website. I capture it and I use it in the opening statement in an electronic presentation. I guess one could argue that's computer-generated evidence. Now, I tell the lawyer who's trying the case, well, you could get up with if you're a medical illustrator, you could get up with a pad of paper and a pen, and you could draw the illustration, and nobody would object, because I'm not using a computer to generate it. I don't have, the crazy part of it is that doesn't make sense to me, that if I can draw it freehand, now we're sophisticated enough, and there's enough programs out there, drawing programs out there, that I can use the computer to draw it. Well, if I use the computer to draw it, is it computer-generated evidence, and do I have to supply notice 90 days in advance? So 3 months before the trial, there would be no way that I would know at opening how I'm going to do opening 3 months ahead of time. So that will lend itself to a debate. Is there a need to fine-tune the rule, fine-tune the statute? I'll leave that for other people. But I can tell you what we do. In opening statement, almost always, because I think opening statement probably is, in my opinion, is the most important part of the trial. It's where I have an opportunity to get up as a plaintiff's lawyer or as a prosecutor to first address the jury, to get them on my team. And I want them on my team. I want them to learn. I want them to be persuaded. I want them to be convinced. I want them to find the defendant guilty right after opening statement. That's what I want to do. Or at the end of opening statement as a plaintiff's lawyer, I want them to all stand up and say that the doctor is guilty of negligence. That's what I want to do. But I want to do it in a way that doesn't appear as if I'm trying to persuade them. I want to lead them down a path so they can draw the conclusion themselves that the defendant is guilty or that the plaintiff doctor is negligent. And you do that, I create the presentations using timelines to talk about the story, gradually progressively leading them down the path to a conclusion that I'm looking for. And opening statement is probably the opportunity where I can put it all together using PowerPoint, using Keynote to do this. In animations, and I'll give you one example, there was a medical malpractice case that involved a DVT, a deep vein thrombosis. And it also involved pulmonary embolism. Person had a clot, went up to the lung, person died. And I wanted to be able, and I wasn't trying the case, but I wanted the jurors to understand what a DVT was. And I could tell them, the lawyer doing the case, one of the lawyers in our office, could tell them a DVT stands for deep vein thrombosis. Thrombosis means a blood clot in the leg. You could tell them that. Or he could draw a leg up there and draw a little circle, you know, and tell them that this is a clot, and, you know, he could do that. But I thought, you know, let's go and see whether there's something available on the internet that actually is an animation of not the DVT in this case, but as illustration, as demonstrative evidence. And so I came up with a little video. YouTube is great. A video that was really kind of cool. It showed exactly how a DVT develops. It showed it moving up to the lungs. It showed how it interferes with the process. And, you know, it was a really good 1-minute video. But anticipating, and this is when I believed that there was going to be an objection. So anticipating the objection that the knee-jerk reaction is, it's an animation, oh my God, you didn't provide this 90 days in advance, when, of course, my opinion at the time, it wasn't computer generated because it wasn't a program that came to a conclusion. But what I did is I took stills of this, and I put them in sort of as a backup. It showed the same thing, it just didn't move. Well, as I expected, there was an objection to using the animation because it was moving, because the knee-jerk reaction was, it's objectionable. So what we did is I just deleted that slide, showed the judge the stills, and he said, well, that's fine. You can use that. It just can't move. It never made sense to me, but that was, in opening statements and in closing arguments and during the course of the trial, as I told you before, documents are really important. And they're boring. I mean, you know, if you stand up and you start reading documents to a jury, where you just lay the document down in front of them, or you have a jury book with documents and you pass it out and you just have them go to page 6. Now, on page 6, and you start reading it to them. I mean, it's horribly boring. It's very difficult for the trial lawyer to be able to do it sequentially. These presentations can be done where slides can be. If I wanted to show, as we did in this case, if we wanted to show a document from Upper Chesapeake Health. Now, what I did is I went on the internet and I Googled manila folder. And I came up with an image of a manila folder. Put it into the presentation. Then I wanted to make it look as if the document is coming from the manila folder, that this is a real folder with records in it. And so these presentations allow you to actually pull the document out of the folder and highlight it now, because this is the important part of the document, to highlight it so we can then go over it in opening statement. Then you can go back to the timeline and you can talk about a time during the hospital stay, another folder with another document as you go through sequentially your presentation. We now, in our firm, we now videotape, for the most part, when the lawyers that are handling the case remember to do it. They're getting better, and that is we videotape every single defendant doctor. It is an expense, not that much more in the scheme of medical malpractice cases, how much you spend on these, but boy, can it be powerful. You could have a video deposition of a doctor. Now, what are you going to do with that? How many people have had cases where they have read-ins, right? You have a defendant that says stuff in the deposition and you want to read it to the jury. So oftentimes the lawyer will stand up and read it, or put a person on the witness stand to play the role and read it and read it and read it and read it and read it. And it's horrible. It's horribly boring. So we videotape it. And what's great about, there's software out there where you can take a synchronized video deposition and you can edit it. And you can take pieces of the deposition and you can show it to the jurors in opening. Now, how is it that you can do that?
Excuse me, Jim, just to clarify.
Sure.
So it's a discovery deposition, but you're videoing.
Exactly. It's a discovery. It's not a deposition. It's not a Debeniese deposition. We're talking about a discovery deposition where I videotape the admissions of the party opponent or the statements of the party opponent. So it's going to come in during the course of the trial. So I want to be able to play this for the jurors in opening. Maybe the doctor said something really important. In this case, there was a doctor that said something really important in a case that I tried last year in Baltimore County. And with all the jazz and all the bells and all the whistles and all the technology and all of that, I lost. And I understand that this isn't going to win the case, but at least I improved the story, I think. But here was an example of a discovery deposition. I'll play it in a second. A discovery deposition. And the doctor in this case really gave me everything that I needed. It kind of led him a little bit, but it gave me everything that I needed that, that I was trying to convince the jurors of, that this 72-year-old man that had HIV, that ultimately died 3 years later because they never tested him for HIV, although he had all the signs and symptoms. And I wanted to be able to show that the Center for Disease Control, the CDC, said if you have signs and symptoms of HIV, you got to test. That's the standard. That's the rule. And that's exactly what they didn't do. So a deposition that we videotaped, I asked this doctor about it.
Would you agree or disagree with the following? All patients with signs or symptoms consistent with HIV infection or an opportunistic illness characteristic of AIDS should be tested for HIV?
Yes, I would agree with that.
Okay. And that was from the 2006 CDC September 22nd recommendation that I read from.
Okay.
Co-figure jurors. I mean that really was it. The argument was, even though he was 70, even though this man was 72, and even though you wouldn't expect a 72-year-old to have HIV, he had signs and symptoms. And they should have tested him, and it was a simple test, and they didn't. I'm over it.
Did you have that in an opening statement?
I feel better now. What's that?
You said you got that clip in an opening
I
statement.
did.
Was it agreed upon by the parties that that was going to come into evidence?
Well, I had yes. I mean, what you do with designations. So I designated a whole bunch of other things. This was one of them, but I designated all of the things that I was going to have as read-ins, or in this case, play-ins. There was a lot of other things that this doctor said, and one of the other doctors from GBMC that said that I was going to play in for the jury. So I put these little clips together for trial. But I wanted to play this one as my very first slide in my opening statement, understanding that the lawyers knew that it was going to be played at trial. I didn't tell them I was going to do it in opening. Now the question is, okay.
I don't know. It's been my experience that in the trials that I've had, that typically exhibits don't come into opening statements unless agreement by the parties, and sometimes even then the judges will say you can't use any exhibits until they're admitted into evidence. It's one thing if you're drawing a timeline or if you're drawing the picture of the bone, that's never an issue, but as far as using an actual exhibit, whether it's a computer illustration, a map, even an anatomical exhibit, it's no, not until it's introduced into evidence.
Well,
Okay,
why?
so wait a minute, wait a
Well,
minute, wait a minute, wait a minute, hold on.
Why?
Hold on. I just heard this attorney make an objection to what I was going to do an opening statement. And you said that because it hasn't come into trial yet, that the exhibit shouldn't be shown to the jurors. Say the word objection.
Objection.
Overruled. I mean, I don't
All right, now
understand, I don't
explain it.
understand that, because I mean, basic case law says that if you anticipate being able to put something in evidence, and agreed, it's a risk. It's a risk. But if I stand up an opening statement and I say that that man right there shot and killed John Jones, and here's the gun that he used, because during the course of the trial, through testimony, I'm going to get that gun in. I'm going to have an expert talk about the ballistics. I'm going to have the doctor say I pulled this bullet out of him. I'm going to have somebody say I matched that bullet to this gun. It's coming in. So under the case law, if it's coming in, you can use it in opening statement. Now, agreed, you run the risk. Now, supposing that it doesn't come in, something happens and you can't get it in, then the question becomes whether or not there's a mistrial going to be asked for and granted, depending on what, you know.
Would you?
Sorry.
But I don't understand that concept. I mean, you know, that's like law school 101. If it's going to come in, there's nothing wrong. And this is part of the debate we had. You know, this is called computer-generated evidence. Quite frankly, the rule needs to be rewritten, because there's a difference between computer-generated evidence and computer-aided design. CAD's been around forever. You know, architects use AutoCAD. They have for years. But they used to sit down at big tables and draw a building. Well, now they do it with a computer. It's not telling you anything. It's just AutoCAD. So this is for another day, as Jim said. But there's nothing wrong with that. I mean, if you objected to that, I would say, come up here. What's your basis? Judge, that's not in evidence. Mr. Gentry, what do you have to say? Judge, it's coming in. It's coming in because it's a statement by a party opponent. I've notified the other side. Yeah, I didn't tell them I was using an opening. Now, that might engage the rule. That's a different issue. But if he says, this piece of evidence, in the same way I stood up and said, this gun, Judge, is coming in. Now, there was a case. I'm going to bust on that. Yeah, there was a case called Finney Frock. And Jim and I tried this case, and this guy killed, this was years ago, he killed his mother and father. And Jim, being clever, went out to the range, and he audio taped the sound of gunfire. And he played it in opening statement in front of Judge Hinkle. And
Won't do that again.
yes. And who was I? Who was on the other
Jennifer
side?
Ace.
Jennifer Ace from the Public Defender's Office, great lawyer. She objects. We go to the bench, and Judge Hinkle says, what are you objecting to? He says, well, Judge, we have no idea if that's the cadence that was used at the time. You know, how quickly were those bullets fired? Was it the exact same sound? He didn't use the gun that was used in this murder, so we don't know. So, and Judge Hinkle sustained that objection. Jennifer moved for a mistrial. He denied it. Okay, went on. He instructed the jury. He walked away pouting. Judge Hinkle said to me later, "What's wrong with your boy?"
No, when I walked up there, he looked at me, and Judge Hinkle looked at me and goes, "What are you doing?"
So there's an example of she was exactly right, but it was just immediately into the case. I mean, like within moments. So in a week's trial, that faded away. Right, but had it, but there was nothing wrong with standing up and saying, here's the rifle Jimmy Finney Frock used to kill his parents. Although it wasn't in evidence yet, it was certainly fair game for opening statement, because in terms of the evidentiary presentation, we were able to link that gun to the murder of his parents. And it was coming in. So it's fair game.
See, I remember, I thought the rifle that we used, the shots that were fired that I played in opening, were from that rifle, the murder weapon. But it's my memory. Anyway, so
does that answer your question?
You know what it?
Yeah, I mean, I've certainly used exhibits in opening before, but typically it's been something either that was agreed upon by the parties, or maybe it's in federal court where if you have a list of exhibits and you use it, it's coming in. But I've also had state court cases before where, say for example, and maybe it's just because there's going to be an objection by the defense. Say it's a prejudicial exhibit of somebody who's had surgery, and I'm on the defense side, and the plaintiff wants to show the hardware in the, you know, that was placed in, maybe it's something that I think is the prejudicial value exceeds the probative value. They want to use it in opening, I object, and the court says, no, you can't use it, you have to wait until it's admitted into evidence. So,
well, that objection is made all the time, and oftentimes there are judges that agree with that. So there is a debate. Our position is that if it's an exhibit, if it's a medical illustration, if it's a diagram, if it's a chart that I'm going to use in my trial with a witness, that I can use it in opening statement. But I risk the objection. And some people will say, well, why don't you give your opening statement to the other side so you can avoid this objection? The problem is I don't want to give my presentation because my presentation deals with the order in which I'm going to talk about things, the emphasis that I'm going to make, some of the points that I'm going to make. It might have bullet points. It's, I think, an unfair advantage to require that each side, or that the plaintiff, if they have a presentation, to give it to the other side. If I was required to do that, I would say most respectfully, Judge, I'd like to have the defense's yellow pad with all his notes on it. Now, that would never happen.
right.
Okay. So do you think in an effort to apply your standards of discretion, but also to avoid any needless surprises at trial, you could file a motion in limine saying, Judge, I don't want to disclose exactly what I'm going to do, but here's the issue the court's going to be confronted with. In general, this debate, what's the court's view, so you don't have to...
Not a bad idea. I mean, I guess you could do that. You could bring it to the judge's attention that you intend on using a PowerPoint presentation. What I normally do is if I have medical charts, diagrams, you know, testimony that I'm going to use in opening, whatever it is that I'm going to use in opening as exhibits that are going to be introduced at trial, I give it to the other side. I send them a letter with on a CD all the exhibits that I'm going to use. I'm exchanging with them my exhibits. I don't tell them that I'm going to use it in opening. I don't tell them how I'm going to use it, but I tell them here it is. Now, if I create a timeline, I'm not going to give them my timeline. I mean, that's sort of, if I have documents, they're coming in. I'm not going to tell them which documents that I'm going to use, what call-outs I'm going to make. But I'll give them, in fairness, I'll give them all of the exhibits that gives them an opportunity to object. Here's what I found in the number of years that I've been doing this. Very early on, when nobody was using this kind of presentation, there was objections from everybody. Now, both sides are starting to use it. You see fewer and fewer objections. It's going to get to a point where I don't think you're going to see any objections. Because remember, this computer-generated evidence applies to both sides. So we're going to see fewer and fewer objections. More judges are exposed to it. They see it every day. They understand it. They understand that both sides are going to use it. And it really isn't going to become, I don't think, a huge issue, certainly in the future, as some of the young lawyers here begin to use these types of exhibits. Somebody?
You said that you would just give the other side, you know, the documents you would use, the exhibits that you would use in your opening statement. You gave some examples, though, of some stuff that you would find on the internet, videos that you'd find on YouTube. In all fairness, I suppose you'd have to give them that too and say, this isn't an exhibit from the case, but to demonstrate a point, I intend to use this that I found on the internet.
If I find a medical illustration on the internet that shows DVT, it's a really cool illustration of it, and I'm going to use it in opening for demonstrative purposes, yes, I give it to the other side. The things that I'm going to use with experts, or the things that I want to use for demonstrative purposes, I do give to the other side. I just don't give them the whole presentation and the organization and how I'm gonna lay it out.
So the hematologist, you gave them just a little clip, or you told them I'm going to use the entire?
No, I get what
the example you gave us there.
Oh, I gave them that clip and every other clip that I was going to use. I probably had a sort of a 10-minute put together 10-minute clip of the things that he said. And this was after I gave it to the other side as quote read-ins. The other side had an opportunity under the doctrine of completeness to say, yeah, but in all fairness, you ought to also play this. If I agree, then I put it in, I play that. If I disagree, there's a hearing. But no, in all fairness, I give them everything that I'm going to use with the defendant doctors. If it's video or if it's written, I give it to them. Let them have an opportunity to object. Let them have an opportunity to add things that they want out of fairness for me to play. And I do that. Just real quickly, because we want to open it up to some, to some questions. You know, what's really interesting is there are a lot of younger, and I don't want to offend any of the older lawyers because I'm one of them, but there are a lot of younger lawyers here that are either just beginning their practice or they're getting into the technology. What you're about to see is using what I think is going to be, it's going to be the state of the art in the courtrooms, and that's the iPad or another tablet. It doesn't have to be an iPad, a tablet. There are now apps out there for lawyers that they can take in. They can take in their iPad, load it with all their photographs, all their documents, everything that they're going to use, and they can use this. With Apple TV, you can do it wirelessly. So I can have on my iPad the document. I can click the document, and it shows up on the screen like this.
This is going to be defense E, Judge, defense exhibit E. Thank you. Echo. So this part of the picture here, Mr. Muhammad, who are these two individuals? That is Derek Kluger, appears to be. Which one's Derek Kluger? With the black suit. All right. And that is Eric Muhammad. Eric Muhammad, yes. Is related to? No, sir. Is he? The gray suit, yes, sir. And how about here? Who are these two individuals? It's myself.
See, he had it. He had the iPad tethered to, so you can use this, and there's a little gadget that hooks right into here, just like this computer does. And I can stand there just like he did with everything, and I have a witness that I want to examine or cross-examine, and I can just hit a button, the document comes up. There's now applications where I can take that document. If I want to specifically highlight a portion of it, I can just take my finger and circle it, and it comes zooming out right in front of the jurors. I could foresee a witness having this up on the witness stand, and if you want them to demonstrate something, a drawing or something, and you want him or her, the doctor, to actually with their finger draw on it, and it shows it's drawing up on the screen. But I think this is what a tablet, whether it's an iPad or something else, is. It's what's coming. It won't be when I'm still around, but it will be when a lot of the younger lawyers are there. The same way a lot of college students now go to school. All the textbooks are going to be on, some of the colleges already, all the textbooks are going to be on iPads, and you're going to walk around campus not with a big duffel bag filled with textbooks, but you're going to walk around campus with your textbook on there where you can read it, take notes on it, animate it, and take it to class with you. Yeah?
How do you preserve that for the record? For the witness drawing something on?
Yeah, that's a good question. Yeah, that's a good question, and let's say that I have a photograph or a document, and I've scanned it in. What I typically do, and I guess there's a number of ways to do it, what I will do is the way we used to do it, and that is I'll have, say, a photograph, and I'll go through the fundamentals, and that is, you know, Mr. Jones, could you take a look at this? What is it? It's a photograph of the scene. Is it a fair and accurate representation of what you saw when you were there? Yes, it is. Your Honor, I would move this into evidence as plaintiff's exhibit number 1 and permission to show it to the jurors via the iPad. Permission granted. Right, Judge? I mean, that's the typical way to do it. Or if it's a document or something like that. Now you have the document that's been preserved. The only thing this is doing is publishing it to the jury. The same way that we used to hand them around. Judge, permission to publish it to the jury, and I'd hand it, and they'd all take a look at it. This they can all see at the same time.
I'm talking about the service.
Well,
yeah. What?
The animations, the circles.
Right, where the witness is circling what he's talking about.
Yeah, the great part about these programs is that once you animate it, you then save the animation, print it out, and it becomes a part of the evidence in the case. Yeah.
And the rule requires that it be transmitted that it be preserved by the clerk and transmitted to the appellate court in such a fashion that you can use programs generally accepted and used in the community to view it. If there's something particular on appeal, then you might actually have to provide the program to the appellate court. But the rule provides both the criminal rule and the civil rule, the criminal rule relates back to the civil rule. It requires that it be preserved by the clerk and transmitted in a form that can be examined by the appellate court.
Okay, so now as an example, here's an accident. Now, I created, it's a fictitious accident, I just made something up, but I used a drawing program. It's fairly inexpensive, pretty intuitive, to do this. So I drew this diagram. This is how I contend the accident happened. And this, I contend, is where the witness, who will testify, I contend that this is where the witness was. The witness is on the stand, and I show the witness and the jurors this, like it is. Would anybody object? And if you did, what would be the basis of the objection?
You need a foundation. You need to have where that witness is located. You need to testify that location, your landmarks or something.
Okay. What about the fact? Objection, Your Honor. It's leading. I'm showing the completed diagram to the witness and having then the witness describe the accident. And it could be argued that I'm leading the witness. So objection, leading, objection, foundation.
The leading objection would be the most appropriate objection. You put your witness on the stand and you throw that up, and he or she's about to talk about the accident, and you throw all that up there right away. You are supplying the answers to the questions that you are about to ask. There's a variety of ways that we can do this. John's going to talk about one of the ways we can do it. But one of the things you could do is lay a foundation. Have your witness describe the entire scene like you often do, and then you show them a photograph. Do you recognize that? Yes, that's the intersection I just described. And how about this, the car that's been wrecked? You recognize this? Yes, that's the red car that I saw. So you could lay a foundation. But if you threw that up right away and just, after John Jones is on the stand and somebody said objection, and if the question is what's your reason, and judge, he's leading the witness. Well, that's absolutely right, because you are suggesting the answers before he's been asked any questions.
So what I do to anticipate that objection to this, I'll have this. I want to use this with my witness. I may want to use it, or I have used it already in opening statement, but I anticipate the objection, foundation wasn't laid, it's leading. So I'll come up with a blank. Now I say to the witness, the truck driver, Mr. Cord, are you familiar with the area of Edgewood Road and Rosewood Drive?
Yes.
And are you familiar with the lane markings at that location?
Yes.
Could you point out to the jurors where the lane markings are and the direction of those?
Sure. There's a center lane between these two, so there's two solid on one side, hashed on the other side lines in the middle of the roadway of Edgewood Road, basically dividing the road into 3 lanes.
Okay. Now he would be doing this. He would be up there. Yeah, and this is northbound. This is southbound. There's a yellow line here and a yellow line here. Is that a fair and accurate representation of the way the lines are in this case?
Yes.
Now, Mr. Cord, where were you when the accident happened?
I was in a truck traveling up to the top of the screen, so that's southbound, right underneath that arrow below the SB mark.
And again, he would be using this. He would say, I was in a tractor trailer headed southbound just prior to Rosewood Drive.
Well, and I guess in terms of the iPad you were just talking about, in the future, he could be sitting there.
He could be sitting there
with the iPad,
and he could be doing that,
and using his finger to describe, the lane markings, and then the next thing you know, Jim throws the lane markings.
Now, Mr. Cord, is that a fair and accurate representation of where you were at the time of the accident?
Yes.
And tell the ladies and gentlemen of the jury what you saw while you were in that cab of that tractor trailer.
there was another car in the center lane, sort of close to me, but obviously up in the intersection that was traveling southbound. At the same time, there was a taxi cab coming northbound on Edgewood Road just prior to reaching Rosewood. The car from the center lane turned and the cars collided.
And Mr. Court, is that a fair and accurate representation of where the cars were and how the accident happened?
Yes.
Okay. So you lay a foundation for it. Now, there are other ways to do it, and we all do it a little bit differently, but anticipating an objection by showing the completed diagram, I mean, this took a little, a little extra skill to be able to do this. I wouldn't suggest that everybody tomorrow can put this together, but it can be done. The same way as if you had a notepad and you said to the witness, come up here and show me, and he drew the lanes. Where were you? And he put an X where the tractor trailer was. This is just a fancier way to do it. However, one could argue that this is computer-generated evidence. Now, I didn't do this until about a week before the trial, anticipating it ain't going to settle. I got to put together an opening. Let me come up with some diagrams. I'll go over, bring my witness in, prepare my witness, develop this based on what the witness tells me, show it to him. No, the car was actually a little bit over here, a little bit over here. So I'll move it around on the computer to where I got, to where I have it, to where the witness says, yep, that's it. Now, what about the 90-day requirement? And this is where I'm not really sure how it all plays out. I mean, is this what the rule intended? I mean, the witness could draw it on a piece of paper. I'm drawing it, or the witness is drawing it, directing me, and I'm using a computer to do it. It's a little bit fancier, a little prettier, but nonetheless, it's the fairness factor is the same whether it's drawn by the witness in front of the jury. It's like this, yeah.
I'm curious what the case law is going to wind up coming out on. If in English or in legalese, whichever way, we make a distinction between computer displayed evidence, computer generated. At what point does the computer stop just displaying and start generating?
Good question, because
computer can display can display anything that you could do with a marker on a whiteboard, or with going back to 4 years old with, what do they call it, color forms?
Yeah, I used to call them crayons.
Crayons. And so we had them at my age too.
No, that's a good question.
What's the frontier
Right,
between display and generate?
And I'm going to show you that. So the answer is animation versus simulation. When does the computer actually go beyond just drawing it? Well, when does a computer actually go beyond just creating a diagram or an image that aids the jurors? When does the computer actually starting to, testify, come up with evidence in the case, draw opinions in the case? Hence, animation versus simulation. And Judge Grimm, in a law review article for the Maryland Bar Association, wrote an article, I think in 2004, and he talked about simulation versus animation. And he talks about computer-generated evidence. Here really is the difference. You have, everyone would agree that this is animation. It's a drawing in sequence. It's the computer isn't gonna come up with any opinions or conclusions. But then when you put this all together, you can actually show the ball bouncing. Like the still photographs of the DVT, of the deep vein thrombosis. All it is a bunch of stills put together in a fancy way that is a demonstrative of it. So, or something like this. All this is a horse running. And they're individual frames, stills, if you will, of different positions of the horse. Remember where you could draw on a pad of paper, a flip pad, and then after you got it all drawn, you kind of whoosh, you can run it, and you could see actually it looked like the horse was moving or the object was moving. That's animation. Here's an example of animation where there is a traffic accident or there's an accident of a spill, something that we know is going to be the basis of which, the foundation of which, is witnesses. Witnesses that are going to say, this is what I saw. Now we're getting a little fancier. Now we're going to actually, not simulate it, but animate it to show the accident. It's all based on what the witnesses have said. The police investigation, photographs that were taken of the scene, where the body was, where the cars were, where the damage was. And this is not meant, this isn't a recreation. This isn't actually how it happened. This is demonstrative of what the witnesses will say. It's a visualization of what the witnesses will say, whether it's an accident or a Now, this is expensive, and it's way beyond what any of us can do. But it's what arguably could be done that would be considered demonstrative. Now the question is, when does the computer then go beyond that and start testifying? Here's an example of a computer testifying. Here's a program. It's called STARS. Here's a snapshot of the program. This is a program where you hire an expert because you want to recreate the accident. You want to simulate the accident. You want the expert to testify based on the data, based on speed and skid marks and yaw marks, and based on photographs, based on all the data that is inputted into the computer. You want the computer then to render its opinion through the expert. And it would look like this. That's not necessarily based on what a witness saw. That's based on data from the investigator of the trooper, from the accident scene reconstructionist, from measurements that were taken, from skid marks, from tire marks, that's where you hire an accident reconstructionist. He has a program called STARS, and this is a real program, but there's probably plenty of them out there. And you say, I want you to recreate how the accident happened. And this is the expert's opinion based on a program that he uses. This is what I think the computer-generated evidence statute really was intending. This is something that you do have to give to the other side. 90 days in advance, and there's probably going to be a hearing, because they have a right to hire their own expert. They have a right to know what program it is, what the basis of it is. This probably will generate a hearing where the expert has to come in and testify, where I think the statute says that the judge can hire an expert, but one of the two sides pays for it. This could be the subject of a Fry-Reed hearing. This is where the eyewitness didn't see this. This is where the program, based on the data, generates its opinion. And you could probably find an expert on the other side that would have a program that would show something completely different. This is no question, this is computer-generated evidence in the way I think the statute intended it to be. It gives the other side a real fair opportunity, because this is an opinion, I want to have my own expert. Not a medical illustration showing the position of the lungs and the clot to illustrate how deep vein thrombosis is and how pulmonary embolism works. This is a program, the one that I use to do those accident scenes. So we have a couple of minutes for questions for us. All right. All right, yes.
All the programs and the materials that you're referring to for illustration, are they in our materials so we can see them?
Yeah, John has on the CD. Then I have, I wrote, I think last year, an article for the Maryland Bar Journal on technology. That article is in there, and I talk about some of the all of these programs, the programs that you see. So you could, for example, Google Smart Draw. And you can download it for free. You can play with it. It is cool if you want to do it yourself.
Just out of curiosity, because I work for the public defender's office, the last one you showed, how much do you know off the top of your head how much that would cost to recreate that?
You mean the last one?
Expert, yeah.
The expert thing?
Yeah.
Well, we've done it in our office a couple times, and we hired an expert and all that. But you're talking about tens of thousands of dollars. I mean, you're talking about a high end where you have a high end case where there's a real question as to liability and how the accident happened. You got a lot of data, but it really doesn't draw any conclusions. You could argue that this data is supportive of your opinion, but you go out and hire an expert. That's expensive. Yeah.
I was unclear on your position on the timeline you created, how you view that, and if you give that in advance or with your exhibit when you do your own timeline.
I don't, because the timeline that I create, let's say it's a medical malpractice case, the timeline I create is based on the medical records. When for example, the patient comes to the ER on such and such a date at such and such a time, that becomes my first event on the timeline. Seen by the emergency room physician, time, and so forth, comes on my timeline, and then the next event. So if I have 10 events based on the records, I create a timeline. I don't see that being discoverable.
Yeah, I agree.
Anything else? Well, we know that you had a lot of choices, and I'd like to thank you for coming to.
On behalf of myself and Christine and the entire Young Lawyers section, we'd like to thank each of the panelists for participating today. And this really helps to end a great year that's been centered on technology. If you're not aware, the Young Lawyers section this year created an app that can be found on our webpage. It's www.yls.org. And on this app, you can have access to the Maryland Rules of Evidence, the Rules of Professional Conduct, MSBA Code of Civility. So this is a great tool if you haven't already downloaded it. Thank you for coming, and have fun at Secrets.